Hello, how are you doing? Welcome to Lawyers Infohub. It's a pleasure to always create content on this platform. Hope you're good. Hope you're fine. Welcome to this great channel. Thank you, my returning subscribers, for always stopping by to know what is new on the channel. And for you who's watching me for the first time, this is Lawyers Infohub. It's a platform where we simplify law. We create law contents to help you become a better lawyer, for the law students to help them become better advocates. Yes, to help them understand what law is all about, what practice is all about. We're bringing people to share their experiences. So sit back and relax. So today we're looking at how to release a matter when it is struck out in court. You see, there are times when a matter can be struck out in court for some reasons, stemming from maybe lack of diligent prosecution, maybe a matter has been adjourned for two times and there was no appearance, the court can strike it out. Sometimes the matter can be struck out when uh, a counsel is supposed to do something and will be three adjournments, is still taking adjournment for the same reason for which the court has adjourned the previous time. You see, there are judges who are very, 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 very serious. They don't play with each court adjournment. They feel if you're not ready to go on, then why are you in court? So some of these judges, when you miss a court proceeding or a court date, you did not send in a letter, you did not call the colleague on the other side, and they feel you are supposed to be in court. Why are you not in court? Some courts will just adjourn, just one, only for one time. On the next adjournment, if you don't show up again, they will strike out your matter. And they feel whenever you're ready, you can bring in your application for releasing. You see, sometimes people feel, well, if they strike it out, there's no big deal. There's also a very big deal. You know, if your matter is struck out, how do you think your client will feel? Because many a times a matter is struck out because parties are not serious or the counsel handling the matter is not serious. Sometimes a court can also strike out a matter where there are no appearance on both sides. Not like one party is appearing and the other party is not appearing. There's no appearance on both sides. The court can just strike it out. Some other time, a court can strike it out by application of a counsel. You are a claimant in the suit. You filed a suit and the defendant keeps coming to court. You are nowhere to be found. You come as you please. So the defendant counsel can bring an application, oral application, to tell the court, my lord, this claimant brought us to court and they are not diligent in prosecuting this matter. On this so date, on this so date, they failed to be in court. No letter to the court, no reason furnished by them by way of a letter or no by any other means to even state why they are not in court. And we are the defendant. If the claimant is not serious in coming to court, then why are we here? So when you make such argument to court and pray the court to strike out a matter, the court can strike it out. Now, a matter have been struck out, what do you do? You were supposed to be in court, you had a flat tire when coming to court, and you couldn't reach the other counsel on the other side, you couldn't send a letter to the court, and the court strikes out your matter. What do you do? Now, what you need to do, the rules has provided on what to do when your matter is struck out. For every jurisdiction, the rules, the rules of the civil procedure rules governing that jurisdiction has laid. You check your rules is there on what to do when a matter is what struck out. So you come by way of emotion. Now, I've seen a court where you have to even apply for a CTC, a certified true copy of the what proceeding for that day wherein your matter was struck out. I think all these measures are put in so that the counsel will be serious the next time. The counsel will know that it's not a tea party. Now, some other courts, you don't need to apply for the copy of the proceedings of the day on the day which your matter was struck out. You just bring a motion praying the court to release your matter. Remember that in bringing this your motion, you need to state convincing reasons why the court should release your matter. There are some courts that if the court is not satisfied with the reasons you've stated, it will not release. It has the discretion to even refuse the application. So you come by way of a motion. Your prayer is an order, pray the court to release so suit number, so you state the name of the parties into the what court list. Now, the fact that your matter has been struck out does not mean that's the terminates it, that's the end of it. No, you can still be your matter can be released there. So you come by way of emotion. In your motion, you state the reasons for which you want the matter to be released. It what happened that is not out of disrespect to the court, that you've been coming to the court, but you did not come to the court the last two adjournments because of so 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 and so. Now in your affidavit, you now expound the reasons for which you're relying, you're bringing in your application. That's the fact that you missed call the three times you missed call, either that your brief was not perfected, that you were sick or you were bereaved, and because you didn't know the lawyer on the other side, there was no way you could notify him, or that you sent a letter of adjournment to the court, but your clerk did not bring it on time. You must find convincing reasons that will make the courts, look in your direction. Then you file your written address. So you have a motion, you have your affidavit, you have your written address, wherein you canvass points, praying the court, urging the court to release the matter. To release the matter. And you see, the fact that your matter is released back to the court list of the court does not mean it cannot be struck out again. If you fail to do what you're supposed to do, the court will strike it out of his docket to handle other cases that are serious. Now, when your matter is released, it is added back to the court courses, and the court will now give you a date either to continue from where you stopped, or depending on what the matter is for. Is it for trial? Is it for mention? Is it for PTC for some jurisdiction, or CMC as we call it? Is it for hearing of application? Sometimes you see someone can file a motion for relisting, and you know what? When your matter is being struck out of the cost list of the court, you now come back and the registrar tells you your matter has been struck out. You make your application that the court released your case. Some courts, they will take that your application, your motion to the court. It is not the court that will put in a date for you to come and move that your motion. The fact that you filed a motion for releasing does not make the releasing automatic. No, you still have to get a date. The court will give a date for you to come and move that application for releasing. After you have moved the application and the court is satisfied that you are now ready to go on with your matter, the court will release your suit back into the general court list of the court. Then the court can now give you a date for, depending on what the matter is for. Now, there are some instances where when the court strikes out a matter, you may not be able to release it. One of those instances is when, for example, the court observes, or there is the other party raises like an objection that your suit is incompetent because the writ of summons was not signed. It's a very strong criminal objection. When such is raised and of a truth your writ is unsigned, when the court strikes out that your matter, you don't go and sign your writ and come back. No. You go back to you have to refile your suit. At that instance, in that particular instance, there's no relisting. Yes, there's no relisting. So there's a general rule, there are also exceptions. That things you need to understand when you can release and when you cannot release. So that instance I gave, in that instance, you cannot release because your suit is even fundamentally defective. So you go redo it and file a fresh suit. Yeah, I just hope you've learned something today on how to release. I earlier stated reasons or instances where a matter can be struck out and what you need to do for the matter to be released. You come by way of a motion. In your motion, you pray the court to release your matter. You state the reasons why you're urging the court to release your matter. In your affidavit, to expand on the reasons you have already stated in your motion, and you do a written address wherein you canvass points, urging the court to look in your direction, to exercise its discretion to be favorable to you in releasing your matter back to the general court list of the court. It's a simple procedure. Sometimes in practice, you find ourselves having our suit struck out. You ask yourself, what do I do? These are provided in the rules. It's just as simple as filing a motion. A date to be given for you to come and move your application. For you convince the court why your matter should be relisted. And that is it. Your matter is relisted. I just hope you've learned something today. Knowledge is powerful. If you have any question, drop it in the comment section. We will attend to it. If you also want us to discuss other issues, other topics, other areas of law, drop it. Send a message to us. We will get back to you. If you're yet to subscribe to the channel, please do hit the subscribe button, share the video, and like it. Thank you. And do stay safe.